Good morning and welcome to the webinar hosted this morning by HR Talk and myself, Nicky Hardwick. The webinar this morning will be on the basics of misconduct, incapacity and poor performance. So really what I wanted to do is unpack today a little bit about what the Labour Relations Act says regarding how managers and employees, well, at least employers, should approach these three different areas. And what I find when I go into employers is very often there is an issue once you get to the end of it because the thing hasn't been dealt with correctly. So the Labour Relations Act in the Schedule 8, the Code of Good Practice on Dismissal, is very clear in terms of how it should be dealt with. And if it's done incorrectly, it could bode not well for employers down the line if a dismissal is ever challenged at the CCMA. As we go through the webinar, please feel free to post any questions. As we go through, I will keep those questions and we will answer them at the end. Once we get to the end, we'll also allow, should there be any questions at the end, if you raise your hand, we will unmute and then you can pose your question, and myself and my colleague Joe will be able to answer those at the end of the webinar. So just in dealing with the issues that employers face, and basically why we're having this webinar is these are the issues that are faced very often by employers, and this specifically comes from managers in dealing with employees. One is a poor understanding of what discipline is and what it means. So discipline is generally done badly because employers and managers don't understand how to discipline, and secondly, what it means to discipline. A poor understanding of progressive versus, excuse me, punitive discipline. So understanding the basics of how many verbal warnings versus how many written warnings and final written warnings. Can you give a final written warning on the first offense? Do I need to give 3 verbal warnings before I can give a written warning? What does it mean to progressively versus punitively discipline someone? Poor record keeping. And then again, the reason why we're having this one today is not understanding the difference between a dismissal for poor performance and incapacity, misconduct, and operational requirements. So this is probably one of the biggest areas where employers fall short is, and I'll go through some examples later, but is approaching a situation for, in terms of poor performance when in fact it should actually be for dismissal, or approaching it from a misconduct perspective when in actual fact it should have been a poor performance. And then also not following the correct procedures based on the type of issue. So when we look at the Labour Relations Act, it's very clear in terms of how we need to approach it. And if you look at the Schedule 8 of the Labour Relations Act, it specifically talks about the fairness relating to the dismissal of an employee. And what they look at is saying, if you get to the point where you're dismissing someone, is it fair in terms of process and is it fair in terms of substantiveness? So the Labour Relations Act is not necessarily saying that you should just dismiss everybody, but when we're looking at when it gets to the ultimate of dismissal, have you followed the right process? So there's 4 different areas, and I'm not talking about operational requirements today. So we're not talking about retrenchments and redundancies. We're specifically talking about dismissals relating to misconduct, incapacity, poor performance. And then I'm not going to go hugely into probation, but they do specifically mention within the Schedule 8, the dismissal of an employee underneath probation. And, a lot of employers say to me, what is the point of a probationary period? And if it is very useful, and if done well, it can really help employers in, firstly, identifying whether an employee, a new employee, will, fit into the organization, whether they are, can perform the functions that you've requested of them. So probationary period is useful, but it must be done in line with the Labour Relations Act. There must be a time frame. You must monitor the person during the probationary period. And if the person is unable to perform the task as was originally set out, you can dismiss a person within probation for failing to do that. So it is quite helpful, and you don't need to follow the same stringent process that would be there, for example, within poor performance. So it can be quite useful. If we just go through the different areas here, so there would be dismissal for misconduct, which is basically an act or omission to act by an employee. In other words, an employee has broken a rule. So misconduct implies that an employee has broken a rule. So they have not done something. It's a willful act. So it could be dishonesty, it could be coming to work late, but it is a willful act. It implies fault of the employee. Incapacity is where an employee is temporarily unable to work or is incapacitated on the grounds of ill health or injury. Then you've got poor performance, which is an employee is unable to perform their duties despite training, guidance, and counseling in the work standards provided. And then, as I mentioned again, is probation is the evaluation of an employee within a probationary period. What is important with probation is that you cannot, with a current employee, implement a probationary period. It can only be done for new employees. All right, when we then look at the types of dismissals and we look at the Schedule 8 of the Labour Relations Act, they basically are saying a dismissal regardless of the reason for the dismissal. There's two main things, and this is what is challenged at CCMA, is the first one is it's a fair reason, and the second one is fair procedure. So if you're going to dismiss a person, you must have sound reason for taking the disciplinary action or sound reason for dismissing the person. So whether it be poor performance, whether it be probation, incapacity, there must be fair reason to dismiss the person. Then you need to follow fair procedure. So fair procedure and a correct procedure needs to be followed. And this is very often where employers are falling short because they're following, and the Labour Relations Act is very clear in terms of the process that you need to follow for dismissing a person. Now, employers will go down the road of dismissing people for incapacity using the misconduct process, or they'll dismiss a person for poor performance using, and very often it is, using misconduct. And as we go through it today, you will see the requirements of the employer are very specific. So if you're dismissing someone for poor performance, when in actual fact it was misconduct, or vice versa, if you haven't followed the right process, when it is challenged at CCMA, as an employer, you could possibly lose at CCMA for failure to follow a fair procedure. So I'm going to start with going through dismissal for misconduct. Remembering, misconduct arises out of an employee's failure to abide by or adhere to the standards of conduct expected by the organization. Again, misconduct implies some form of fault on the part of the employee. This is very different, and as we go through incapacity and poor performance, both of those, being incapacity and poor performance, do not imply fault. So misconduct is where an employee has defaulted on something. They have not followed the rules. It's very different. So in terms of procedural fairness, the employer should have disciplinary rules and regulations that provide a standard of conduct required by employees. It is specifically mentioned as well is that in as much as you must provide for the disciplinary rules and regulations, that there are some rules that don't specifically need to be mentioned. So for example, you don't need to have a rule that says you can't steal, as an example. So some rules are just ingrained, but you should have a set standard of rules or code of conduct that you require employees to behave. Okay. You also need to, where possible, implement corrective discipline rather than punitive discipline. So generally, a dismissal is not appropriate on a first offence unless misconduct is so serious and of such gravity that it makes the continued employment relationship intolerable. So very often when I go to employers, they say to me, well, I didn't know I could dismiss on the first instance. So when you're looking at any kind of management of discipline, the best way to go forward is to look at it and say, as your employees, you're trying to teach them to behave. So where you can allow a person a second or third chance, you need to do that. You need to teach your employees what the correct behavior is. Why rules are important is just as an example. In my organization, if you were caught smoking in a non-smoking area, I might give you a written warning. But if I work at a petrol station, smoking in a non-smoking area may come in that instance with an immediate dismissal. Okay, so certain rules may change per organization, which is why you need to tell your employees what you're expecting of them. So that in instances like that, if I came from a company where it was a written warning, I understand that in this company, it could be a dismissal. Also, in terms of procedural fairness, you must always conduct an investigation. That investigation doesn't need to be a completely formalized investigation, but you need to ask the questions, you need to understand what has happened, and you need to unpack what the person has done. Again, very often what I find is that employers don't do this investigation. They don't ask the questions, and we sit in a disciplinary hearing only to find that the employee's actions were reasonable. So it's very important as an employer that you conduct that investigation. It sounds very formal, but an investigation is really just asking a handful of questions to unpack why the person has done what they've done, and was it against the rules and regulations, or was it against the code of conduct? The employee must be notified of the inquiry and be given reasonable time to prepare. The employee must be allowed to respond and have an assistance of trade union or fellow employee, and they must be given the reason for the dismissal. So when we look at the Labour Relations Act, there are other rights which I'll go through, but this is basically what is required in terms of procedural fairness. What is important, and we'll go through it just now, is you'll see how different it is to poor performance and incapacity. Then when we have a look at substantive fairness for misconduct, okay, the basics are, did the employee break a rule? And if yes, was the rule valid or reasonable? Was the employee aware or could have been reasonably aware of the rule? And has the rule been consistently applied in the organization? And is the dismissal an appropriate sanction? So that in a nutshell is basically how employers need to approach misconduct. So when we're looking at the fairness of both procedure and substantive, basically that's how it would look at in CCMA. I know that there's case law that may change certain things in terms of how a rule is applied, but basically in terms of the Schedule 8, that is what is required of an employer. Now we go on to poor performance. So if we look at poor performance, if we look at what poor performance is about how the employee performs the tasks required of him or her as determined by the standards of performance for that position. It implies no fault. So what is important here is we need to differentiate between negligence and poor performance. If we're looking at the true definition of poor performance, we're basically saying that despite everything, the employee is unable to perform according to the correct standards. So if we look at the procedural fairness and what is required by Schedule 8, the first thing that an employer must do is conduct an objective assessment. So as an employer, you need to decide, you need to do an assessment on whether or not the person is meeting the standards. Then what you need to do is provide appropriate training, instruction, guidance, and counseling. Employees must be given a reasonable time to improve. And again, we just need to unpack here, there are obviously different circumstances. So if a person comes into your organization with all the requirements, they've had the experience, then possibly that may be different. But when we're looking at poor performance, these are the guidelines that must be put in place. If there's certain things that are slightly different, well, then obviously those can be taken into account. We need to investigate reasons for poor performance, and job transfers should be considered. Okay, so this is probably one of the key things. If we're looking at a dismissal for poor performance, there's an obligation on the employer to look and to see, is there a job elsewhere? Okay, so because it's a no-fault termination, there is more of a requirement for the employer to look elsewhere and to do more for the employee. If we look at the misconduct, there isn't that requirement. We then look at substantive fairness. So has the employee failed to meet the performance standard? If they have failed to meet the performance standard, was the employee aware or could have reasonably been aware of the required standard? Has the employee been given fair opportunity to meet that standard? And then again, was the dismissal appropriate? Now we're going to go in, and I'll do a comparison just now in terms of the three. We go into the dismissal for incapacity. Okay, so incapacity again, is different to misconduct and poor performance. Incapacity is an employee's inability to perform all or part of his or her duties on account of ill health or injury. Okay, again, it's different to poor performance and it's different to misconduct. So when we're looking at procedural fairness, basically we look at whether there's a pattern of intermittent sick leave or lengthy absences from work. Has the extent of the employee's ill health or injury been investigated? So have we done an investigation to identify what is the job that the person is doing, and is their ill health or incapacity affecting their ability to do that job? Okay, then we have a look at if they're unable to do that particular job, to what extent can't they do that and for how long? Then we need to look at the work circumstances and the job. Has it been considered for adaptation or modification? So again, as an employer, I have an obligation to go, well, if this is the job that you're required to do, if you can't do a part of that job, can I modify or adapt it? If I can't do that, can I look elsewhere and see if there's another job for you to do? In the instances of substance abuse, have I looked at counseling or rehabilitation? Okay, again, I want to say to you that these are just, every circumstance is different, and whenever you're approaching this within your organization, there are circumstances that may be different. There are things that, rules, etc., that we may need to look out of this, but this is basically, if we're just going to look at a basic sort of step that we need to follow. If we look at the substantive fairness, is we're basically looking at whether or not the person is capable of performing the work. If the person is not capable, the extent to which the employee was able to perform the work, the extent to which the employee's work circumstances could have been adapted, and was there any availability of another kind of work. Again, with dismissal for incapacity, it's a no-fault termination. So again, it implies no fault on behalf of the employee. So if we then just have a look at the overview. So now, and I'm going to go through where it goes wrong, but if we look at misconduct, it implies a fault on behalf of the employee. You're basically, so with discipline, you're trying to teach your employees to obey your rules. So you're disciplining them. It could be a small, it could be a verbal warning, but you're trying to get your employees to behave in a way that you want them to behave in your workplace. With poor performance and incapacity, it is no fault. So the requirement, so when we look at the difference in the comparison, under misconduct, there is no requirement for the employer to look at whether or not I can provide the person with another job, whether or not I can adapt the position to suit the employee. Under poor performance, there's more of an onus on the employer to look at alternatives. So if a person is unwell and can't come to work, can I give them time off? Can I accommodate that illness? So with poor performance, I need to provide training. I need to explain the standards. I need to allow them time to improve. With misconduct, it's not like that. So you do need to do progressive discipline, but there are certain instances where progressive discipline doesn't apply. So when we look at where it goes wrong, so just as a very basic example, and this happens time and time again, but let's take an employee who has failed to perform her duties, which has really resulted in a loss to the company. The company doesn't, and again, it's a very basic example, so I'm not saying, go down this road, but what the company does is they automatically assume it's gross negligence or dereliction. They go down the road, they have a disciplinary hearing, and they dismiss the person. The person then takes it to CCMA, and at CCMA, evidence then comes out, which is possibly or not or whatever, presented at the hearing, where it finds out that the person didn't have the training, wasn't guided in the work standard, and it actually should have been poor performance, just as an example. Okay. At CCMA, what they would then do is they would find that you failed to follow the correct procedure because it actually should have been poor performance. So what you have failed as the employer is you failed to conduct an objective assessment. You haven't given appropriate training, instruction, guidance, and counseling. You didn't allow the employee reasonable time to improve, etc., etc. So now we sit in a situation where you could end up having to take the employee back, or you're going to end up having to pay, you know, compensation at CCMA. But as the employee, as the employer, you fail to follow the right process. The same thing happens, for example, when an employee takes too much time off work for being ill, as an example. What happens is I find employers then go down the road of charging the person with, you know, something relating to misconduct, when in actual fact it should have been followed from an incapacity perspective. I'm not saying in every situation it is definitely incapacity or it's definitely poor performance, but as the employer, you need to investigate properly which line you actually should fit in. Is it a rule that is being broken? Is it a fault of the employee? With incapacity, there's no fault. It can't be the fault of the employee. With poor performance, again, it's not a fault of employees. So before you end up at CCMA or in an appeal hearing or whatever it is, ensure that you're following the right processes. Okay, I'm just very briefly going to go through some of the things just to unpack, now that we've looked at the various lines, to unpack a little bit about, you know, dealing with discipline, dealing with poor performance, so unpacking how we actually approach these things. I know that a lot of the people that are in this webinar today, I've worked with for many years, so you probably already know this, but I'm just going to go through it again. So when we look at progressive versus punitive discipline, and again, this is where a lot of employers go wrong, is because they don't approach it so correctly. When we look at discipline, excuse me, is one of the things that I always say to people is you should always approach discipline in your workplace almost as if you were dealing with your child. So if you were trying to teach your child how to behave, you would, depending on what the child had done, you would approach discipline in a certain way. It's the same sort of situation when we're approaching discipline in a work situation. Some transgressions, some things that the employees do require more severe punishment, and in other instances, it is not as severe. So what discipline is basically doing, as I said before, it's trying to teach employees how you want them to behave. And in certain instances, you can give them, you know, little guidance like a verbal warning or a written warning to say you need to come into line. But progressive discipline is basically the process of using increasingly severe steps or measures when an employee fails to correct a problem after giving reasonable opportunity to do so. Punitive discipline is basically giving a severe punishment. So punitive discipline would be for serious things such as gross negligence or dishonesty or that sort of thing. Assault as well. So those sorts of things, when it's something severe like that, you wouldn't give a person a number of opportunities. So for example, assault, you wouldn't give someone a verbal warning, which is basically giving them 2 or 3 opportunities to do it again before you would have a disciplinary hearing. In that situation, assault is just not acceptable. So you would go for punitive discipline to say, we don't accept this here. Theft is an example. Theft is not a situation where you would say, okay, well, you've done it once, we don't like it, so please don't do it again, and give them 3 opportunities to basically try again before you actually fire them. Late coming, on the other hand, somebody does it once, you say you shouldn't do that, you need to come to work on time, so I give you a verbal warning because I'm saying to you, you need to come to work on time. If they do it again, well, you say, okay, well, you've done it again within the time frame. Here we go, here's a written warning. So the idea with progressive is you're basically trying to get your people to come back into line by slowly punishing them harder, unless, of course, it's a more serious thing. So again, I go back to disciplining of your children. If you have children, basically, if your child sticks their finger in a plug, you're probably not going to say, you know, you naughty sausage, don't do it again. You will probably give them a smack on the hand, because they need to understand if they do it again, the punishment for that is really, really severe. If, however, they leave their toy outside, well, you may slowly get the punishment more severe as you go because you're trying to get them into line. Minor transgressions can be treated progressively. So depending on your disciplinary code, you may call them minor transgressions or major transgressions. So minor transgressions, as I mentioned before, would be things like late coming. It could be, you know, a number of things. I can't think off the top of my head, but late coming. It could be failing to, I don't know, switch off lights or whatever it is. It could be failing to follow basic processes, those should be treated progressively, whilst major transgressions are normally treated punitively. Now, with punitive action, that could be things such as final written warning, or it could lead straight to dismissal. When we then look at the different types of disciplinary actions, remembering, again, before verbal warnings, you could get counseling. So counseling could be, sitting with a person and saying, you've done X, Y, and Z. Do you understand the rule? Do you know that you shouldn't be doing this, etc., etc.? Or if the person does understand the rule, you could go straight to verbal warning. A verbal warning, in as much as it says verbal, should always be in writing. And it should go on the person's file. But basically, a verbal warning is really saying to the person, if you do this again, the discipline is going to start getting more severe. Then you move on to a written warning, final written warning. You can have, as a punishment, a demotion, but this would be as an alternative to dismissal. Remembering that with a demotion, it has to be accepted. You cannot forcibly demote someone. So it's got to be part of a process. And it can be as an alternative to dismissal. And then just to be clear, with verbal warnings and written warnings and final written warnings, you can't have, for example, I go into companies where the person has got 3 final written warnings on file, or 3 written warnings for the same thing, okay, within the same time frame. The idea with warnings is that a final written warning is a final written warning. You don't give people 3 final written warnings. You would basically, if the person has broken a rule, so let's, for example, say late coming, you would then, after having spoken to the person a number of times, if they're not listening, you would issue them with either a verbal or a written warning. There is a time frame which will be based on your disciplinary code. It's either 3, 6, or 9 months, whatever your code says, which the warning is valid. If the person then transgresses again during that time frame, and it could be they do it another 3 times, you then progressively, your warning would get higher. So if we started on a verbal warning, you would then move to a written warning. You don't give the person 3 verbal warnings, because again, you're not progressively disciplining. You're basically just disciplining them the same amount. So you would start with a verbal warning as an example. If they do it within the time frame, so if the warning is not expired, you would then move to written warning. If they do it again during the time frame, let's assume it's 6 months. If they do it again once or twice, or however you want to play it, you would then move to a final written warning. And if they do it again within that time frame, you would then move to a disciplinary hearing. If you don't discipline correctly, remembering what we're trying to do is get people to comply. If you carry on doing the same thing over and over again, so for example, just giving them verbal warnings, eventually what people learn is that there is actually no discipline. What happens then is, when we're looking at consistency, if you're giving people final written warning after final written warning for the same thing, when you eventually go to a disciplinary hearing and you say, I've had enough, they are then confused, because they're saying, well, I didn't know that if I did it again, you were going to go to a disciplinary hearing, because every other time that I've done it, you just keep on giving me a final written warning. So it's quite important that you continue. So much as, again, the same as children. If I keep on shouting at you, or if I just scream at my child for the same thing, so they leave their toy out and I scream, and they leave their toy out and I scream, but there's never anything different. The one day that I go and I take out my shoe and I smack them on the bum, they're very confused, because every other time, the only discipline they got was me just screaming at them. So it's important in terms of consistency that you apply it across the board. Then if we have a look at disciplinary hearings, within the Labour Relations Act, they are very clear in terms of how you need to approach disciplinary hearings and what the rights are that need to be afforded to employees. But this must also be dealt with in terms of your disciplinary procedure. Remembering that basically the Labour Relations Act is saying that a person needs an opportunity to defend themselves. The hearing doesn't necessarily need to be formal, with attorneys, etc., but you have to give a person a fair opportunity. Once you get to a disciplinary hearing, they've got to have fair opportunity to defend themselves. They have to know what you're charging them with. You have to treat people fairly. You don't necessarily need to have a disciplinary hearing per se for a verbal warning, written warning, or final written warning. But again, that depends on your disciplinary code. Okay, then we're just going to very broadly go into, again, dealing with incapacity. So when we look at incapacity, and again, I found that employers are very nervous of incapacity. They don't know how to deal with it because people get hung up on what is wrong with the employee. So as an example, if an employee brings in a medical certificate, if on the medical certificate it doesn't say what's wrong with the employee, then they won't accept the medical certificate. There's no reason why you need to know what is wrong with the employee to deal with incapacity. So when we look at incapacity, basically, we look at an employee who is either temporarily unable to work. So if you look at an employee who takes time off, more than twice in 8 weeks, or has been booked off for an extended period of time. What the Act basically requires is that as an employer, we should investigate the extent of ill health or injury. What that really means is that, and the easiest way of doing that is to basically unpack what the person's job is. So to say, for example, Nicky is an HR consultant. She goes out to clients. She drives most of the day. She's got to sit at her desk. She needs to work on a computer, as an example. And I would then, and I'll go into the Employment Equity Act just now, but basically what the easiest way for me to do that as an employer is I say, that's Nicky's job. I then write a letter, obviously with Nicky's permission, and I say to the doctor, dear doctor, this is Nicky's job. This is what she's required to do. Doctor, please can you tell me, with whatever is wrong with Nicky, okay, I don't need to know it, obviously it's helpful if I do, but please can you advise if Nicky can perform this job that she has here. If, as an example, I have a massive back problem and I actually can't sit for 80% of the day, what would then happen is the doctor then comes back and says to Nicky, or says to the employer, look, Nicky can't sit for most of the day. But if you give her a workstation in which she can stand, then she can actually do her job. So as the employer, I can then look at it and then go, can I adapt Nicky's work environment? Can I make it that she can stand for most of the day? If I can do that, if I can modify Nicky's job, well, then Nicky can come back to work. If I can't do that, so I can't adapt it, then my next question would be, well, how long is Nicky not going to be able to do this? The doctor may come back and say, well, it's actually only going to be for the next month. Myself as the employer then again go, can I have Nicky off for a month? Can I accommodate? We're not talking about the payment of sick leave. We're not talking about that element, but can I accommodate this, or at least Nicky's time off work? If I can do that, well then I say, yes, Nicky, I'll give you time off work, or I can adapt it. If not, I would then go down the road of saying, well, unfortunately, Nicky can't do the job. I can't accommodate. And therefore, I would then terminate Nicky's employment on the basis of incapacity. Just going very broadly again, in terms of the Employment Equity Act, and specifically with incapacity, it is not unfair discrimination to distinguish, exclude, or prefer any person on the basis of the inherent requirements of the job. It also says that testing of an employee is prohibited unless it's justifiable to do in light of the inherent requirements of the job. So when an employee is unable to come to work because of incapacity, ill health, or injury, I can then request that the employee goes for a medical to basically determine whether or not that person can do the job. And if they cannot do the job, I can then terminate them on that basis. All right, and then finally, when we look at poor performance, again, this is slightly different, and there's a lot of things that are written in the Labour Relations Act, but basically with poor performance is, again, as an employer, I need to sit with the person. I need to ensure that they understand the requirements of the position. I need to ensure that they understand what the requirements are. So for example, you need to meet your deadline by the 5th of every month. I need 100% accuracy. You need to respond to queries within a certain amount of time. You need to make 20 widgets a day. Once I've then unpacked that the person is not meeting that, and again, it may be a case of the person has, we'll only get to this once we've unpacked this, the person may have all the skills that are required. They may have all the equipment. They may have everything that they need. So the poor performance has got nothing to do with the person unable to perform, but they're choosing not to perform. So when we go through poor performance, we need to go, we've explained the requirements, we've explained the performance in relation to the requirements. So we've told the person why they're not performing, what are the things that they are not meeting their targets, and we need to give them time to improve, okay? Once we've done that and we put instruction and time in place where they can improve that, if they can't remedy it, we eventually get to a point where we have a performance hearing and we basically unpack that with the employee and we said, we've given you, you know, these guidelines and you're still not meeting what we need you to do. And then we would start to unpack whether or not there's another job that the person can do. And if there isn't, we would ultimately dismiss the employee. So when we're looking at poor performance and incapacity, even if we get to an incapacity hearing, part of that incapacity hearing, again, is looking, did we look as the employer if there was something else that the person could do? Have we unpacked that with the employee? Because those are big requirements that are required by the Labour Relations Act. So as you can see, when we're unpacking these things, if you follow the wrong process, you're going to come short when it comes to, you know, when it comes to CCMA. All right, so those are basically the areas that I wanted to unpack with everybody today. What I'm going to do now is to start to unpack and open up the floor for any questions that anybody has with regards to possible, you know, uncertainties in terms of how to process these things going forward. What I do want to say, though, is what is key is to ensure that within your organization, one, managers are appropriately trained in how to deal with these things, because very often, and I talk about the issues that I've placed at the beginning, the biggest areas that we find when we go into companies is that managers don't actually understand the difference between the three. So they approach it badly or they don't approach it at all. Okay, so things are just left, and eventually you have employees that are just doing whatever because they're not disciplined, or you have people that just take off sick leave or are not performing. And so what happens is you end up with a workplace that with disgruntled employees because you've got people that believe that they're working harder. It can be managed pretty easily. People are worried about conflict. They're worried that people won't like them. But if you follow the Labour Relations Act, it actually becomes very factual and easy, inverted commas, to deal with. So the two things, as I mentioned, is one is to have your rules and regulations and your code of conduct in place and to ensure that people understand that. And secondly is to ensure that your managers or the people dealing with your people understand how to go forward. So it's important to train people adequately, and the training doesn't need to be very high level. It's really just understanding how to approach the three things. So what I'm going to do now is I'm going to open up the floor. And I'm going to just go to some of the questions. All right, yes, the presentation, I will make it available to you. As far as I'm aware as well, we do post this on YouTube, and if you need to get a copy, we can send that to you as well. So one of the questions is can we also address the issue of employees refusing to sign the warning? Okay, so that's a good one as well. So as part of the warning is what should happen is when you sit with an employee, remembering, as I said before, a verbal warning, in as much as it's verbal, should be in writing. So when I sit with the employee, and the process that needs to be followed is I call a meeting with the employee, or I have a discussion with the employee to unpack what has happened. After listening to the employee and remembering, whether it's a verbal warning or a disciplinary hearing, you have to give the person fair opportunity to respond to whatever it is that you're alleging that they've done. If after you've unpacked it and you believe that their reason is not valid, their reason is not reasonable, and you're choosing to give them a verbal or written or whatever warning, the employee has the right to either sign or not sign it. The not signing of the warning doesn't invalidate the warning. So people very often think, if I don't sign it, it means it doesn't exist. So in that situation, what would happen is if the person is choosing not to sign the warning, then you would call somebody obviously at a higher level than the employee to come and witness the fact that you've issued the warning to the person, you've explained the warning, and the person is refusing to sign. What is important, and that the warning will be valid and will go into the employee's file. Okay. But what is important here is that people, for some reason, believe that when they don't sign the warning, is that by not signing it, they've begun the appeal process. Okay, so it is important that if a person fails to sign the warning or refuses to sign the warning, that they understand that it doesn't automatically mean an appeal has started. So I've had situations where we've ended up at CCMA for a dismissal where the person has had a verbal warning, a written warning, so everything was followed correctly. When we get to CCMA, the person states, no, I didn't sign the warning, so I was appealing it. Then we get to written warning, and so what happens is we now get to CCMA. If the commissioner finds it valid and fair that the employee did not know that the appeal process hadn't started, if we find that the verbal warning, written warning, and final written warning were invalid, then the dismissal is invalid. So you need to make sure that if an employee is refusing to sign a warning, which is their right, that you're clear that it doesn't automatically start the appeal process. Okay, so hopefully that has explained that. Can you address the relevant documentation related to supporting a decision to proceed with performance hearing? Okay, what documentation needs to precede the final decision? So, okay, so when we're looking at poor performance, it is slightly different depending on the situation. So with poor performance, once we've had a look at and we've unpacked what is actually the issue. So remembering for each employee, it may be different, okay? The person may have a degree and so they don't need training. So when we look at what you would probably need is we would need to unpack, have you had meetings with the employee? So that needs to be documented. Have you unpacked the what they're not doing, so the standard that they're not meeting? Have you given them opportunity to fix? And when you're having these meetings, you would need to unpack what it is that they need in order to get better.
If I may, just add here, a lot of employers are very scared about performance management, and they need not be. Typically, when you get to the stage where the employee is now formally to be managed on performance, it will probably lead on of poor performance leading up to that point. In my past practice, what we've simply done is you place the person for 3 months on that performance management process. You're very clear about the objectives they need to meet. You're very clear about the support that you're gonna hand the person, provide to the person. But here's where the employers don't get it right: is they don't have regular meetings. So if I'm performance managing somebody, a subordinate or assisting another division or something like that, we will schedule those meetings in advance, 3 months, on a fixed date, every Friday, for example, or every 2 weeks, every 2 weeks we get a meet for the next 3 months. That type of arrangement to ensure that the employee is properly aware and cannot afterwards say, well, process wasn't followed, or I wasn't given enough opportunity, or I wasn't provided with support, I was unclear what was expected of me. You make it clear in those meetings and you document those. A lot of employers ask us for documentation. You can do a simple Excel tracking sheet or a simple Word document where the expectations that were laid out that the person needs to meet is clearly made, that person is made aware of it, and you can then do follow-up emails in between as well. Say, well, you're behind, not doing this well enough, that kind of thing. But what you need to show when it leads to dismissal is simply that you have honestly tried your very, very best with this employee, and the employee has not responded accordingly.
So yeah, so I think with poor performance, the documentation is a little different, obviously, to warnings, because warnings you have a very specific approach, and with poor performance, as well as I think with also incapacity, every situation is different. So I think, as Doe has said, you just need to make sure that you can justify, that you've done. So if I just go to the, I don't know if I can go back now to the other slide, but basically it's just making sure that you can prove as an employer that you have done everything that you could have done reasonably to ensure that the person was able to get to a point where they could perform. So I don't know if that has, hopefully that has answered all the questions. I don't know if anybody else has any other questions. as I said, it will be available. The presentation will be available afterwards. We do post, as I said, on YouTube. It does take a little bit of time, but I will send you the presentation in PDF format so you can have a look at it. And if you have any particular issues that you want to call me on, you're more than welcome to give me a call and or email us. Thank you for joining us, and hope to see you soon.